Sue Moroney.
Thank you, Mr Chair. I want to return to the part of the bill that I was, well, it's obviously part two, but the clause of the bill that I was referring to when the Minister took a call before. And what I was talking about was the fact that that industries will end up with ACC levies being set on their differentiated rate rather than a residual levy once Part 2 comes into effect. And what I hope is that when that happens, that we won't see a repeat of some of the problems that this government has exhibited when they have they've tried to get out of a situation by deciding which workplaces are safer than others, which industries are safer than others, and which carry less risk. And I really hope that we don't see that shambles reoccur as a result of the residual levy being removed, because under section 336A, what it specifically allows for is that the effective date of removal of the residual levy for the work account can in fact mean the earlier of either the 1st of April 2019 and a date appointed by the Minister by notice. And it seems today that the Minister indicated that it's going to be Part B of that section, of that part, that she is going to invoke, and that she is going to propose after a consultation process that on a date yet to be determined next year, that's when the residual levy will be removed. So the impact of that is, it sounds like it's going to be that everyone is going to get a reduction in their levy, but that's not the case. Under the work account scenario, it does track back to 1999 when, and the residual levy was set at that point. It was set in order to make sure that the injuries and accidents that have been incurred as of that date would be fully funded. And the way that this Parliament chose to do it then was to put a residual levy on. The residual levy was placed on those industries based on what their accident and injury record was at the time. Now, what we know is for a whole lot of those businesses, particularly the ones in the accredited employer scheme, that the accredited employer scheme has had a measure of success, and part of the measure of that success has been that the historic injury and accident rate has reduced. Now, that's good news. But unfortunately, because their residual levy has been in place for those companies, they haven't necessarily seen the full impact of their reduction of injuries and accidents in their workplace, because the residual levy has kept it, I guess, at that 1999 level until we got to full funding. So it is a measure of success, but I put it to this House, it is the measure of the success, and I think Nick Smith actually backed this up when he was speaking before. It is a measure of success over a 30-year period. Not a 7-year period, not even a 10-year period. It's a measure of success over a 30-year period, that this ACC system is so successful, that the model is such a fantastic model, and yep, it's a Kiwi owned and operated model. It's owned by the state. It belongs to the people. It is doing so well that the residual levy can be reduced earlier. And that is not because of what one government has done. It is because we've set up a fully sustainable model over a period of time. And that's why I started my earlier contribution by saying that this Part 2 exposes how badly that government, and Nick Smith in particular, tried to mislead the New Zealand public when he was the Minister of ACC over what was going on with the solvency of ACC. Clearly, Part 2 shows that that was all a sham.